Fooled you guys. You probably thought I wasn't coming out today, but good morning to everybody, or afternoon, or whatever it is. I don't even know what it is. Good morning, afternoon. So I have to say hello to whoever's here to give them the credit for standing out here. Hello to Mr. StreamYard. Again, that's my normal joke. Strength in Numbers, Splat, Born Free Films, Toe Cramp, Donna, Rondell, The 1-1, Barbara, Miguel, that's who I see right now. And to anybody else who's watching or will watch, greetings. Uh, I think today's video hopefully will be quick or reasonably quick. It'll bring you up to speed as to what happened in yesterday's hearing. Hi, Scott. Yesterday's hearing and what the next steps are and where we are, etc. So before I start that, I just wanted to mention a couple of things. One, I don't know if you've had this experience, but and especially relevant now. But hi, John, by the way, and Ambi and Market Watcher and Northern Nice Guy Gary. I don't know if you all had the opportunity, but I watched this drone footage, right? And this drone footage goes on and on and on. That was a joke, by the way. And as a result, kind of my X post recently, X or Twitter, I still don't even know what it is. I don't know if anybody knows what it is. It's the only company that's called by the name it's not. If you never noticed that, it'd be like me calling the LA Dodgers the Lakers, and that would be acceptable. But whatever, everybody still calls it Twitter, even if it's X. But just because it's, I've been a little bit off kilter for obvious reasons the last 8 days or so. If I offended anyone with my X posts, I apologize. I really do. I apologize to heart. I honestly did not think you could read. And last but not least, and this is really something that was kind of surprising to me, I live quite a distance from my office. Not really, but for the joke, I do. I live kind of a long distance from my office, so I ordered an Uber this morning, and the Uber driver came, picked me up. I sat in the car. Kind of as we were like midway through the ride, I tapped him on his shoulder, and he almost jumped out of the car. He apologized to me and said it was his first day as a Uber driver, and before that, for the last 20 years, he had been driving a hearse. Boom. All right. So before I start, and I'm going to be reasonably quick, I want to focus on one. This just struck me. It was funny. So yesterday it was the court hearing. I referenced it. I said I was going to do a live. I didn't post because I was waiting for certain information, which I will talk about. But I was literally waiting for information, waiting for a document so I could look at the document, and waiting to speak to somebody. And I look at I look at X comments, whatever I do, and I look at comments that are made on the videos, whatever, and I would say 98, 99% of the comments are really nice. And I honestly, I appreciate everybody's kind comments. I know other people aren't aren't as lucky sometimes, but I'd say like a high percentage of comments from all you nice folk out there are really nice, and I thank you for all that. Sometimes they're not, and they're annoying. So I just wanted to just give you, like, this one got me yesterday. So I didn't respond. People were asking me what happened at the hearing. I was waiting for information, so I wasn't responding because I didn't want to give a incorrect answer or a answer I didn't feel comfortable with. So some guy named Inked Up Devon, hello Inked Up Devon, by the way, thank you for reaching out. He said this, and I just found this funny, and it's gonna be quick, but I just found it funny. No problem posting on other topics, but can't respond here, and just gonna lead everyone on until tomorrow, creating suspense. It probably didn't go his way in court, and he's trying to figure out how to spin it to his followers. Now, one, it's not my way in court since I'm not the attorney, but anybody who's followed me knows that this is kind of silly. The whole point is, and I don't know why anybody would be um, critical of anyone doing something for free for them and for their benefit, and the real reason was because the answer wasn't complete. And the funny part was he referred to a post. I made one other post yesterday. The post was a joke about the Iranian missiles. And the reason I was making a joke about the Iranian missiles, because they were making a bunch of claims about when they were going to do things. So I posted as a joke that the Iranians apparently have come out with this new missile that is invisible, silent, leaves no remnants, and no damage. Now, I think you could get that would make it non-existent, so that would be kind of a joke. This person, I guess, didn't have the ability to comprehend that, and he criticized. He thought I shouldn't be commenting on anything else, and that I was somehow keeping all my followers in check. So followers, you are free. You're free at last to do whatever you want. Anyway, thank you, Inked Up Devin, for reaching out, and now you understand why I did not post prematurely before I knew all the information. So let's talk about what the issues are that occurred at the court hearing yesterday. So, one, if you recall, since we did it about a week ago, I think, we talked about the audit, and the audit required certification from 5 attorneys. Now, they don't have to certify the audit, apparently, but they have to certify certain information. And I think we discussed that 3 out of the 5 had done it, 2 were waiting. So as of the hearing yesterday, the 4th has now complied. So there is now only 1 attorney who hasn't complied. That attorney is in New York. His name is, by the way, just so we put it out there, he works at Warshaw Burstein in New York. His name is Alan Pollock. I don't know how you pronounce his name. It's P-O. Let me spell it for you, because if somebody wants to nicely contact Alan and urge him to complete the information he needs to submit to GTII, I wouldn't stop you as long as you did it nicely and weren't harassing Mr. Pollock, because according to the attorneys for the receiver, he hasn't responded at all, and that's a big firm, so it's not like it's a little mom and pop firm. So if any of you want to reach out to Alan and find out why he hasn't complied, I can give you his telephone number if you so choose. And if you put it in the comments, if you want his telephone number, I will, once I post the video, if you want it, I will post it. And I can also post the senior partner, managing partner of that same firm. His name is Frederick Cummings Jr. So the 2 attorneys, Alan Pollock is the attorney who hasn't yet certified, it's my understanding. And Frederick Cummings Jr. is the managing partner of that firm. Perhaps they would like to hear from GTI shareholders. I'll leave that up to you. If again, after I post this, if that's something that I see like a bunch of people want telephone numbers, I will post it on in the comments. And if you politely ask why they haven't completed the work necessary for GTII, then I can't stop you. But again, it has to be done in a nice way. So Alan Pollock has not yet responded. So what did the court do? The court then set a hearing in 3 weeks. And sometimes, by the way, I will talk about legal things, and I may just describe what's going on without giving a reason or opinion. And the reason is sometimes I may not want to assert the opinion because I don't want to help the other side. And I'll give you an example here. So Alan Pollock isn't officially in the case. So whether a court can bind somebody like that with an order if they haven't appeared is the question. And so yesterday at the hearing, when the Receivers Council said 4 out of the 5 is signed, but Pollock hasn't signed yet, what do we do? Then at that point in time, the judge decided that the Receivers Council should personally serve Pollock or at his firm in New York, and then I think the judge would be comfortable then entering in a contempt order if they didn't comply. So what the understanding was that the Receivership Council is going to serve. In other words, there'll be some process server is going to go out and physically deliver the notice to Pollock, and there'll be a hearing in 3 weeks to see if Pollock has complied by that point in time. If he hasn't complied, then theoretically the court will hold him in contempt or will initiate a contempt hearing against him. So we shall see how that goes. And in the meantime, again, if people want to reach out and urge him to comply, or urge the managing partner to comply, I can't stop you from doing that, from calling Warshaw Burstein to call Mr. Pollock or Mr. Cummings Jr. and ask them why they haven't completed what is required of GTII. Because the way I think of that, by the way, also is if the audit was not completed, and the reason why it wasn't completed was because this guy didn't sign off, that would have killed a deal. And I think that would make them a target of a big lawsuit. That's my view. Not that I know anything. But maybe they could use some encouragement, because I think once they're done, I think the audit's done, it could be submitted, and obviously we're rolling at that point in time. So anyway, the court is keeping tabs on top of Pollock, and now there will be at least a contempt at issue. And again, if you guys want to contact those guys and nicely encourage them to complete their task, then so be it. So another court hearing in 3 weeks. This guy will be served within 2. I may reach out to these guys too, myself, in a nice way, of course. So that was the first thing that was decided. Second was the omnibus objection. If you recall, the receiver filed this objection as to 87 different parties who had purportedly illicit shares of dubious nature. And the last hearing, a freeze order was entered, and that's in place. So none of those shares of the 87 can be transferred, sold, or anything like that. All frozen, including that of the Reichmans, Griffin, etc. Now, one of the things I didn't talk about, because again, I didn't want to give it to the opposition, when and I just told you what had happened. The issue when somebody is seeking relief, so in the omnibus objection, what the receiver was seeking against parties to the lawsuit was seeking to take a different procedure than normally would be available. Because normally, if you're in a lawsuit, ultimately, if you make it to trial, you can have a trial. So the receiver cleverly was trying to circumvent that and establish a procedure where we get the shares back without, in essence, permitting a trial. So there was a lot of pushback by the other side. And I could understand that, because it's a due process issue, and whether it would withstand an appeal, that's the issue. So after the last hearing, after the freeze order was granted, and it is granted, so all those shares are tied up, the parties got together and they negotiated a resolution as to that. As to all the parties in the lawsuit, that would be including Mr. Reichman, Ms. Griffin, and apparently her daughters are referenced, or family. As to all of those people, they're excluded from the process, whereby the court was going to set up this claims process that everybody who has these illicit, or quote unquote illicit shares, can make a claim, and then the court would rule on it, and that's how it would be resolved. So everybody who's not a party to the lawsuit, that's how everything's going to be resolved. As to just Reichman and Kathy Griffin and her family, that will be resolved in the normal course of litigation. So I expect a large number of those outstanding shares of the 87, and by the way, it was specific. It wasn't entities or anything like that. My understanding, this is what I was waiting for, by the way, my understanding, it was specifically just the names. So it wasn't like Reichman's trust or anything like that. Specifically just Reichman, his shares, so shares that were for him, and Kathy Griffin, just shares for her and her daughter. Doesn't mean they get to keep them, just means that the process by which they will be challenged will be through trial or not. As to the other 87, or whatever the difference is, maybe 83, this claim process is going to be ongoing. They'll have a chance to challenge it. A lot of them will just return the shares out of hand, and that's where that stands. So the only difference was the freeze order remains in effect, and I know the freeze order was important in particular for AI-versity, because they don't want to be they don't want the bad guys to benefit, or the so-called bad guys to benefit in any transaction. So that freeze order is in effect, and the only change is now, as to of those 87, everybody other than Reichman, and Griffin and daughter are going to be treated through a special process, and either they will challenge that they're entitled to keep the shares or not. And my estimation and guess is that most or almost all those shares will be returned and hopefully be canceled. As to just the specific shares that are named in the name of David Reichman, Kathy Griffin, and their daughters, that process will just be normal litigation with a potential trial. I expect, because I was told before, that there'll probably be mediation. Mediation, as I think I mentioned before, and there may be ongoing discussions. I don't know. Mediation would be where a third party comes in and tries to help negotiate the parties. Now, I do know specifically that AIversity would not be happy if either of the old management retain any shares at all. And I have that on very good word. That's not something they would accept or be willing to tolerate. So I don't think it would be a bad idea also for shareholders to communicate to the receiver or receiver's counsel that we don't want, if you agree with AIversity, and if you want to make that, I think, make that transaction more likely to happen, you might want to communicate that to the receiver, that you don't want any of the old management to retain any shares, notwithstanding whatever the necessary process. Now, I don't know if that's going to be happen, because sometimes there's a lot of practical reasons why you would give up the share, you would let them retain shares, and there may be other reasons why you might let them retain shares. And obviously, these guys are going to have my guess. I don't know for a fact. I'm speculating, just opinion, not legal advice, not dog catching advice either. But I suspect that these guys might have problems with the IRS and other regulatory and other agencies of other nature. That's my guess. And again, my other thing was I wouldn't mediate with them unless they agreed to be open to giving X number of shares just to start off with. I wouldn't go in if they was, excuse my language, but it's a legal term. I wouldn't just go in if they was dicking around, to be honest. But that's where we are. So I believe there's ongoing discussions amongst the Reichman and the receiver party. There's ongoing discussions with the other 87. So I expect at some point in time to get a list or a summary, probably filed with the court, of all the shares that have been returned, how that sits, how long would that take? I expect that's probably like 30 to 60 days is my guess. In the meantime, they're all frozen. So that is going forward also. And again, I would be really playing hardball with the defendants. I wouldn't be giving an inch. I would let them go broke. I would let them go to jail. I would let them, whatever. I would let them suffer the consequences of their misconduct, as it's referenced by the receiver. I don't know. I don't have firsthand knowledge of anything, but I would let them, if the receiver is correct in those reports, I would let them suffer the consequences fully of their actions. I don't know. The question about Wes, I didn't really know. I don't really understand the question. I think Wes, but I'll answer it this way. I know Wes Christian. I don't know him personally. I have never worked with him, etc. I know he was involved in a spoofing case with GTII. That case was settled or dismissed. Whatever. I won't say anything more than that. Wasn't particularly pleased by the way that the outcome or the handling per se, but I wasn't involved. Didn't know. Wasn't involved. That's kind of all I will say. So let's kind of like go over what happened. So yesterday, what happened? The court issued an order to show cause to be delivered to Alan Pollock regarding the fifth person to certify the audit. That would be the last person. I think at that point in time, the audit would be ready to go. That's a necessary element to moving forward with any transaction and to get the stock relisting. The next hearing's 3 weeks. I'm hoping that within 3 weeks, Alan Pollock has signed off by then. And again, if you guys are interested and want to contact him or the managing partner, Frederick Cumming Jr., in a very nice way back in New York, I can't stop you. And there's a hearing in 3 weeks to talk about that issue again. As to the omnibus objection, that was the objection to the those 87 groups of shares. There's an agreement as to how it's going to be handled. Everybody other than Reichman and Griffin are going to be treated through normal litigation with a potential mediation ongoing or discussions ongoing, and everybody else will be treated through a limited process where they have to make a claim to contest that the shares are valid or just give them up, and that's ongoing. Is Luke Rabari on that list to return? I think he was on the list of 87. I don't know. I do not know, I'm not involved with that. I don't, I'm not the attorney, etc. But he is of the 87. If I recall, he was one of the 87 listed on that list. I don't know if there's been any discussions between the Receivers Council and him. My guess is yes, because he was involved, but I don't know. That would be just purely guessing. So the objection. So I think that the share, the 178 million shares, I think a lot of that's just going to work out over the next 60 days where they're given back. And as to Reichman and Griffin, either they will work out a resolution of those shares, or they will litigate those shares. Separate and apart from that, I think those people have other concerns that would take whatever other monies or shares they might own. So, that's just my view. But I would let them, to be honest, I think this, if the receivers reports are correct, this is about the most corrupt administration I've ever seen, period. If the receivers reports are correct, just based upon what the receivers said. So that's the third thing. That's the process. And I, like I said, AIversity would prefer that they get nothing. That's how they would prefer, and they don't want that. But the fact that there's a freeze permits the transaction to go forward. No guarantee the transaction will conclude, but it's still going forward. And I know that the AIversity and the receiver are in constant daily contact, so everything is moving forward. So that's it in a nutshell. The hearing from yesterday, the next hearing's in 3 weeks. We can talk about Alan Pollock, the guy who hasn't signed. Any other information I get, I will pass on. And that's it for today. We moved a little step further. We got one additional person off the certification list. We got clarity as to the process for trying to get back those shares. And that's where we are. So everybody, and some really bad jokes. Everybody have a great day. I will keep you apprised as we go on. Take care. And again, to everybody out there, I really appreciate your kind words, and hang in. Be nice. Have a great day.